I'm Madison Minot, and today I will be discussing a legal theory that fundamentally alters our understanding of the law. We refer to this philosophy as legal realism. The majority of people think that judges just enforce existing laws. We have a tendency to view law as something stable, rational, and foreseeable. However, legal realism disputes such a notion. It implies that law is shaped by what judges really do in real-life situations rather than being a collection of rules found in books. To put it in another way, legal realism contends that law is both theory and practice. Early in the 20th century, legal realism emerged mostly in the US, and it developed a response to a previous idea called legal formalism. Formalism saw law as a sort of science in which judges could apply rules and in a predictable and automated manner to always get the right answer. But a number of academics and judges started to recognize something crucial. In actuality, court rulings weren't always reliable. Even with the same facts and the same statute, different judges may reach different judgments. This brought up a crucial question. Why do results differ so much if law is meant to be objective and rational? Legal realists believed that comprehending the law requires looking at how courts really resolve cases rather than just reading statutes. Oliver Wendell Holmes Jr. Highlighted that judges are impacted by pragmatic considerations such as societal demands and consequences that law has molded by experience rather than only reasoning. Carl Llewellyn emphasized the value of researching actual court rulings, pointing out that the law is frequently ambiguous and subject to interpretation. Jermone Frank concentrated on the human aspect of judgment, suggesting that bias and individual experience might affect choices. Together, they influenced legal realism's basic concepts. Legal realism is based on four key ideas. Law is uncertain and open to interpretation. Real-world outcomes matter more than theory. Judges are influenced by personal experiences and beliefs, and law evolves with society. Real-world examples help illustrate these principles. Sentencing in criminal proceedings is one basic example. It is possible for two people to conduct virtually similar crimes, yet get different penalties. Formalists may view this as a mistake or an inconsistency. However, legal realism clarifies that these variations may be caused by a number of variables, including the judge's point of view, the specifics of the case, or more generally, societal issues. Canadian courts' interpretations of the Canadian rights or the Canadian Charter of Rights and Freedoms demonstrates the application of legal realism. The Charter encompasses a wide range of rights, including equality and freedom of expression, because these rights are not strictly narrowly defined. Judges have a great deal of latitude in how they interpret them. For instance, courts frequently have to strike a balance between the right to free speech and other significant interests, such as ensuring public safety or safeguarding individuals. Depending on how they see the matter, judges could approach this balancing in different ways. It illustrates a fundamental tenet of legal realism. The meaning of law is not just determined by the words found in legal texts, but also by interpretation and execution. The significant influence on the contemporary legal system is legal realism. It has affected the way the law is taught in schools, moving an emphasis on memorization of rules to the analysis of actual situations, recognizing that total objectivity could not be achievable. It also has promoted increased openness regarding judges' roles. In conclusion, the conventional understanding of the law is unchangeable and objective, and the objective is contested by legal realism. It demonstrates how law is dynamic, adaptable, and complexly linked to society. Legal realism provides us with a better practical understanding of how the legal system functions by contracting on what courts actually do rather than what the laws say in theory. The most important lesson, though, is that law is lived rather than written. Thank you for listening.